that
I
with
gave
her.
you hospital papers. I gave her everything.
I'm also
I had
handed
a
you.
doctor's appointment and everything. That's what I'm
I've got
telling
5
you.
more years that I could add on to that.
Oh, man.
I can give you up to 10.
No.
You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I went to the hospital and everything.
I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition because of the judgment entered against. All right, ma'am. Are you Devon Atkins? And Miss Atkins is on probation for the 3rd-degree felony offense of injury to an elderly person. That's started at May 23rd of 2022. There was a motion to adjudicate probation filed. She entered pleas of true to counts 4 and 5. Does the state have testimony with regard to counts 1, 2, and 3?
Yes, the court would like.
Yep, I think I would.
Young man called, Ms. Shakita Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Cole, would you please state your full name for the record?
Shakita Cole.
How are you employed?
I'm employed at Jackson County Adult Probation.
And as a adult probation officer, is it your responsibility to supervise an individual on this probation by the name of Devon Atkins?
Yes.
Do you see Ms. Atkins in the courtroom here today?
Yes.
Can you point to her identifier?
Right here in the blue jumpsuit.
Your amended record reflect Ms. Cole has identified your probationer Devon Atkins.
Record will so reflect.
And Ms.
Printing.
Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they're supposed to do to follow the court order?
Yes.
And each one of those in detail is gone over with them so that they understand everything that they're required to do.
Yes.
Was Ms. Atkins so advised?
Yes.
At her intake?
She was advised at her intake and at a TTM at the Melton Center in person.
Okay, and describe for the court what a TTM is.
A treatment team meeting.
Okay, so in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes.
And were in fact a majority of those things intended to help her?
Yes.
Was she advised that she was to report to the Community Supervision Department when directed by yourself and the court?
Yes.
And did Ms. Atkins, based on your review of the file, fail to do that on multiple dates, including but most likely not limited to November 4th of 2024, November 19th of 24, and, and was that in violation of her probation order?
Yes.
Did you address that with her and inform her it is important to report if you have something come up, you need to let me know?
Yes.
And did she do that?
No.
Was Ms. Atkins as a condition?
Stop right there. Did you hear that? Devon Atkins was on probation for injuring an elderly person, a 3rd-degree felony. That's serious. Probation is a deal. Follow the rules, stay free. But she already broke them. Missed reports. Didn't update her address. Didn't prove community service. Ignored treatment. And now, the state is stacking violations like dominoes. Here's the kicker. Probation isn't forgiveness. It's the last chance before prison. And the judge, already sounding done with excuses. So buckle up, because this isn't a story of, oops, I forgot. This is the slow, brutal march from second chances to 5 years behind bars. Question for you. When help is handed to someone and they throw it away, should the court give another chance or slam the door shut?
Her current address.
No, she did not.
Anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court to know in conjunction with your testimony and your updated PSI.
The main thing is her mental health. She refuses to address that. We've made appointments for her with Spinal and she didn't attend the appointments. She's 100% when she was out unmedicated. So that kind of interfered with her completing her services. And she maintained contact with the victim in the case. So that part, her grandmother was trying to be there for her because of the mental health difficulties. And that's the main thing that we were trying to get her to address.
Okay.
Let's line this up like a hit list. Strike 1, didn't report when ordered. Strike 2, no updated address. Strike 3, community service, either not done or not documented. Strike 4, ignored mental health treatment set up by probation. And here comes the dagger. Strike 5, she kept contacting the victim, her own grandmother, even when ordered not to. Every single one of these is a violation. One would be enough to tank probation. She stacked 5. The law doesn't care if you kinda tried. Probation is about compliance, not excuses. And when the violations pile up this high, the question shifts from, will the judge revoke, to how many years is she going to
At
get?
some point in time in November of 2024, was Ms. Atkins violating the condition the court had imposed that she not to have contact with Ms. Thibodeau for Ms. Thibodeau's safety?
Yes.
Any questions about that? About
No.
the count, that's count 8 with the contact? Okay. Then, at this time, based on the testimony, I am going to find counts 1, 2, 3, 6, 7, and 8 true. Again,
Boom. That's the sound of the hammer falling. The judge just said the word every defendant dreads. True. Not 1 count. Not 2, 6. 6 different violations officially confirmed. In legal terms, this is game over. Once the judge declares those violations true, probation dies and prison becomes reality. The only question left, how long? Remember, this isn't petty stuff. We're talking injury to an elderly person, a felony carrying up to 10 years in prison. This isn't a slap on the wrist anymore. This is the court saying, we gave you rules. You broke everyone. Now you pay the price.
Updated PSI we have, as well as I think there was some issues from the jail. If you look at those issues and activity, I think that goes directly to her mental health state. Unfortunately, she has not been on a mental health caseload. I think that definitely would benefit her, as well as, being able to take advantage of any services that phenotype MHMR may have, or any programs that probation deems appropriate for her. I have had conversations with her, and many meaningful conversations with her, where she has addressed to me her desire to take advantage of those activities if those available to me. She did understand that she had the safety opportunity that didn't go well, but I don't think the mental health issues were addressed, mainly just substance abuse at that point. I think if we can get a handle on that, or get some work done with her to address the mental health issues, I think she'll do a lot better in this situation and be able to complete this assessment.
I mean, as far as when
Hold on.
is not taking patients.
well, it sounds like you had appointments that you missed that Ms. Cole made for you. Did she go to regular Safe P or special? Hold on.
Special needs.
So she's already been to special needs
Okay.
Safe P. So that was a whole 6 months plus aftercare of drug and mental health help. So Ms. Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment in Port Arthur because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Ms. Cole set for you, at least one, how many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho. I don't have those problems. I mean, some people do that. I don't know.
Well, you obviously we don't know what you need because you won't even go do the evaluation. That it sounds like you haven't been on medication that would be what?
Evaluation where?
At Spinal Top.
That's what I'm telling you. That's not. I don't have that. I'm not a psychopath. That is for.
It's psycho.
Did you catch that? The defendant just told the court she's not a psycho. Wrong move. The judge wasn't accusing her of being insane. This was about mental health treatment to stabilize her. Evaluations aren't insults. They're lifelines. By rejecting the help, she's not looking misunderstood. She's looking defiant. And here's the bombshell. The difference between mental illness and legal competency. You can have struggles, but still be competent. Competent means you understand the charges and can make choices. And what the court is seeing right now is a choice. Refusing help, rejecting treatment, breaking probation. And those choices are about to cost her everything.
The court has had to deal with Ms. Atkins today, and it's been kind of just this runaround circle.
Well, and in addition, I am going to find judicial notice of the court's file. Ms. Atkins was evaluated for competency to stand trial not that long ago. I think it was in January of this year. And I have that report. And the finding is that Ms. Atkins is competent, understands the nature of the proceedings, and is then just really making a choice not to follow through with what programs have been given to you, Ms. Atkins.
This is the knockout punch. The judge just read the report. Devon Atkins is competent. She understands the courtroom. She knows the rules. She's making choices. And once competency is locked in, the "I didn't know" defense collapses. At that moment, every violation turns from "maybe she couldn't" into "she wouldn't." The credibility war is over. The judge flat out says, "I don't believe you." That line hits like a sledgehammer. Because in sentencing, credibility is currency. Lose it and you're broke. From here on, the only suspense is how heavy the hammer is going to swing.
I was gonna die, so I really didn't have much of a choice.
Okay.
It's my life in jeopardy.
I'm going to find that you entered your pleas of true to counts 4 and 5 freely and voluntarily. Again, I'm finding counts 1, 2, 3, 6, 7, and 8 true. Find sufficient evidence to find you guilty, and at this time find you guilty. Don't talk over. I'm about to sentence you to prison, and how you keep talking over me is about to start adding years
Here's where
onto that.
courtroom drama becomes self-destruction. The judge warns her, "Don't talk over me or I'll add years. I can go up to 10. That's not bluff. The felony range is 2 to 10 years, and now her mouth is literally making the case worse. Judges don't like being interrupted. It screams disrespect, lack of control, zero accountability. And guess what? Those are the same red flags that justify max sentences. She's not just breaking probation, she's showing the judge, Liv, why she can't be managed on the outside. And when a defendant argues mid-sentence, the only thing they're proving is the judge's
I
point.
need you to sign that with
I gave you
her.
hospital papers. I gave her everything.
I'm also
I had
handed
a
you.
doctor's appointment and everything. That's what I'm
I've got
telling
5
you.
more years that I could add on to that.
Oh, yeah.
I can give you up to 10.
Have 'em.
You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I went to the hospital and everything.
I'm handing you a
3
written
times.
admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered
I
again.
don't have a
And
choice.
there it
I'm
is.
not-
Guilty. The judge sentences Devon Atkins to 5 years in prison for injuring an elderly person. Probation revoked, game over. She'll get credit for time served, but the hammer came down hard. Add to that the firearms restriction she now carries under Texas law. Her freedom is gone, her rights are cut, her second chances are burned. What's the takeaway? Probation is not a free ride. It's a last chance. And when you spit on the rules, the court will shut the door. Choices have consequences, and this defendant just learned the price. 5 years locked up. If you found this breakdown shocking, smash that like button, drop your verdict in the comments, and subscribe for more courtroom meltdowns and legal takedowns. Share this case, because everyone needs to see what happens when excuses run out.